So welcome, and thank you for joining us today for another presentation in our series on civic engagement. My name is Wendy Rowe, and I work in the mobile home program at CVOEO. The mobile home program works to provide mobile home park residents greater control over their housing through organizing and education in order to protect and improve housing rights and living conditions. We have a mobile home hotline that is available Monday through Friday. We'll provide you that hotline number at the end of our presentation. Our presentations over the last year for the Civic Engagement Project have included talks on subjects such as Know Your Rights, This is What Democracy Looks Like, a bylaws training for the St. George Community Co-op, and an emergency preparedness training. You can find all of these recordings on our website. So today, I'm happy to introduce Jess Hyman, Director of the Fair Housing Project and Associate Director of the Housing Advocacy Program at CVOEO. Jess will be presenting on fair housing law and why fair housing is important to all of us. So without further ado, I'll hand it over to you, Jess.
Thank you very much, Wendy. It's a pleasure to be here on screen today. I'm going to share my screen and we will get started. The Fair Housing Project is one of CVOEO's statewide housing advocacy programs, and we work to increase fair and affordable housing opportunities all over the state, especially for people in protected classes. And we do this through workshops and trainings for housing and service providers, municipal officials and planners, housing developers, and also the general public. And we do consultations and referrals for anyone experiencing discrimination in housing. And we also coordinate the Thriving Communities Initiative, which is a statewide partnership that seeks to increase awareness about the importance of fair and affordable and inclusive housing. And it's important to note for this presentation that I am not a lawyer. I'll be talking about fair housing law, but we encourage you, if you have any specific legal questions, to contact our friends at Vermont Legal Aid. So today we'll be covering a little bit of the context and history of fair housing and fair housing protections here in Vermont. We'll do an overview of what's covered. We'll talk about reasonable accommodation and reasonable modifications, and the exemptions to the law, and what happens if you experience housing discrimination and how you file complaints. So first off, what does fair housing mean? I would encourage you to pause for a moment and just think about what fair housing means to you. So the official definition of fair housing is fair housing is the right to equal opportunity in housing choice and the right to buy, rent, or live in a dwelling free from discrimination or harassment. And why is this important? So we know that where we live has a huge impact on every aspect of our lives. And this has been especially reinforced over the past year of the COVID pandemic. Where we live determines where our kids go to school, the ease of getting to work, our access to healthcare and recreation, what kind of physical danger we might be exposed to, our physical environment. And also where we live is important to our economic and social stability. Our homes are also tools for generational wealth development. And they provide opportunities for connecting with the broader community and opportunities to be involved in local decision making. And so having enough quality, affordable housing is good for all of us. It's good for ourselves, it's good for our families, and it's good for our communities. And this is especially important in a tight housing market. So the Fair Housing Act passed in 1968 and enshrined protections into federal law. But it's not just, these protections aren't just a modern invention. In fact, way back in 1866, the Civil Rights Act of 1866, which was enacted right after the Civil War, grew out of an attempt to give freed slaves the ability to enter into contracts and lease agreements, including home rentals and ownership. And this covered all properties. However, that law was never sufficiently enforced. And over the years, there were patterns of discrimination, especially against people of color. So jump ahead to the 1930s, when racial discrimination in housing was rampant and segregation was enshrined in this country's law and culture. For example, the New York State Legislature allowed insurance companies to build housing projects for whites only. And the city actually gave them tax concessions. The federal government issued bank loans on the explicit condition that African Americans be barred. And there were racially restrictive covenants for neighborhoods that barred African Americans from purchasing homes, even here in Vermont. And then as a result, most of the money that was made from the suburban housing boom flowed exclusively to white Americans. Populations of color were regulated to central city neighborhoods, and that meant that the American dream of homeownership and upward mobility and generational wealth development just wasn't accessible to so many people. And so all this and much more led to systemic segregation in our cities and towns, and people fought back. In the years leading up to 1968, there had been several attempts to pass the Fair Housing Act, but it wasn't until Dr. Martin Luther King Jr.'s assassination in April 1968 that the legislation went through, and the Fair Housing Act passed soon after. So the Fair Housing Act is enforced by HUD, the Department of Housing and Urban Development, with state agencies like the Human Rights Commission responsible for testing, litigation, and enforcement. So housing discrimination and segregation are still pervasive around the country, and also here in Vermont. And so it's important to recognize what our rights are and how to know when illegal discrimination is happening. So when the Federal Fair Housing Act was passed in 1968, it enshrined into law protections based on a number of what we call protected classes. And so the protected classes are disability, and this isn't limited to physical disability. It covers physical and mental disability. People with cognitive or emotional disabilities are covered as well as people in recovery from addiction. Other protections are based on race, sex, color, national origin, religion, and family status. And family status is generally defined as having children under the age of 18. And states have the ability to add additional protections. And here in Vermont, we've added several. The additional protections in Vermont are receipt of public assistance, and that includes vouchers such as Section 8 vouchers or CARES vouchers. It also includes 3 Squares Vermont or other public assistance. Other protections are based on gender identity and sexual orientation, marital status, and that would either be being married or unmarried, age, and also victims of abuse, sexual assault, and stalking. And Vermont has a sort of a little wonky protected class, which is basically a protection against NIMBYism, not in my backyard. And that is a protection against making planning and land use decisions based on the income of a prospective resident. So when do these laws apply? So these laws apply in all types of dwellings. So houses, mobile homes, apartments, condos, shelters, group homes, migrant housing, long-term transient lodging, etc. And Fair housing law also covers everyone connected with housing. So that means owners, property managers, leasing agents, administrators, maintenance staff, service providers, cleaning staff, contractors, lenders, resident associations, co-op members, residents, etc. Everyone is required to follow. Everyone connected with housing is required to follow fair housing law. And it's also important to note that all advertising and statements are covered as well. So there are some instances where a property would not be covered, but even in the case where there's an exemption, all advertising or statements must follow the law. So who's protected? Well, everyone seeking housing, and that includes renters, home buyers, people looking for mortgages, or homeowners or renters insurance, and also anyone living in their home as well. And that includes residents or caregivers. And mobile home residents are often in a very unique situation because they're owning their home and renting your lot. And so these protections apply on both sides. So what are some examples? So housing discrimination occurs when a person is treated differently than others based on their membership in any of the protected classes. And so this can show up in many different ways. So for example, refusing to rent or sell housing, saying that a unit or a lot is not available even when it is, setting different terms or conditions or privileges, or steering people towards different housing sites or services. Also, any threats, intimidation, or harassment based on someone's membership in a protected class, or retaliation for filing or supporting a discrimination charge. It's also against fair housing law to not respond to or to not provide a reasonable accommodation or modification. And we'll talk about what those are in a little bit. So here in Vermont, more than the majority of housing discrimination complaints received by the Human Rights Commission and Vermont Legal Aid are based on disability. And that's followed by complaints based on family status and then also race or skin color. So what is reasonable accommodation? So people with disabilities, and that whether they be physical or mental disabilities or being in recovery from substance abuse, are allowed under fair housing law to have reasonable accommodations. So a reasonable accommodation is a change in a rule, policy, or practice that allows someone to have equal enjoyment of their home or property. And in Vermont, the rules around mobile homes have a specific reasonable accommodation clause. And the law says it is unlawful discrimination for a park owner or management company to deny a person with a disability a reasonable accommodation of building rules or policies if such accommodation may be necessary to afford such person full enjoyment of the premises. And everyone involved in sales, rentals, and financing housing must make reasonable accommodations for people with disabilities. And the key thing is what's reasonable. So first off, there must be a connection between the requested accommodation and a disability, and it can't place undue financial or administrative burden on the property owner or co-op, and is not a threat to health or safety of other people or the property. So one of the most common types of reasonable accommodation that you may be familiar with is service animals. So a park owner or co-op may ask if the animal is a service, assistive, companion, or support animal. And under fair housing law, all of these terms are interchangeable. A service animal may have a specific amount of training versus a support animal, but all of these types of animals are covered under fair housing law. A park owner or co-op may ask may ask for medical verification that the applicant has a disability, but not what that specific disability is. But the park owner or co-op may not ask what's wrong with the applicant or any details about the disability, or for any specific certification or documentation about the training of the animal. And of course, you should never share any personal medical records. So a reasonable modification is a change to the physical structure of the building. And some examples of those are a wheelchair ramp or a grab bar in the bathroom. And owners of units with federal operating subsidies must make and pay for these modifications. But private park owners or co-ops must allow the residents to make a reasonable modification at their own expense. And in that case, the resident may be required to return the property to its original condition when they leave it. So like with a reasonable accommodation, someone applying for a reasonable modification must indicate that they qualify as a person with a disability, but is not required to reveal the nature of their disability. And similarly to reasonable accommodation, the reasonable modification has to be reasonable as well. So it can't put an undue financial stress on the owner and can't infringe on the rights of anyone else. So a few things to keep in mind. We've mentioned already that reasonable accommodations and modifications are for people with physical, mental, and emotional disabilities. It's also important to note that these requests are often very specific and require a case-by-case analysis. An owner, a park owner, or co-op may create a form and a process for handling reasonable modifications and accommodations, but they can't require that the occupant use the form to make a request. So this is really important because verbal requests are just as valid as written requests. Even if it's a request made in passing, that still counts as a valid reasonable accommodation or modification request. And park owners and co-ops must respond to all requests in a timely manner. And there are sample letters on the CVOEO website that make it easy for you to make your request. So what are your rights when you're making a request? You can be asked if you have a disability or if the disability isn't obvious. You may be asked what the actual modification or accommodation that you're requesting is, and you may be asked what the connection is between the disability and the specific modification or accommodation. The questions that you may not be asked are what kind of disability you have, or any question that would require that you disclose your medical history. So what are the exemptions to fair housing law? So there are a number of cases where fair housing law doesn't apply. One of those cases is refusal to rent to a person under the age of 18. Also, nonprofit religious housing and also senior housing are exempt from fair housing law. And then also another exemption is if a rental unit is too small for the number of people desiring to live in the property. So this can be an exemption only if based on occupancy standards or fire safety or septic capacity, not on arbitrary limits on the number of people per bedroom and never on the number of children. And then another exemption is multi-unit buildings with 2 or fewer apartments, but only if an owner or a member of their family lives in one of the apartments. Your very first call, if you have any questions about whether what you're experiencing is illegal housing discrimination, is to call us here at CVOEO. Call the Vermont Tenants Hotline at 802-864-0099 or call the Fair Housing Project directly at 802-660-3456. We can help you determine whether what you're experiencing is illegal housing discrimination and make a referral for next steps. You can also call Vermont Legal Aid, Legal Services of Vermont, or you can file a complaint directly with the Vermont Human Rights Commission or with HUD. If you are experiencing discrimination, it's very important to document what's happening. So we recommend that you keep a journal of incidents of discrimination, write down what happened, when it happened, who was there, and any other details about the event, and then keep any documents related to this discrimination. So any emails, any text messages, any letters, make sure to save them and print out copies if you can. And the reason that it's important to keep all these things is that illegal discrimination can be very difficult to prove. And so the more documentation you have, the better. And fair housing complaints can be don't have to be filed right away. You have up to a year to file an administrative complaint or 2 years to file a lawsuit in court. So what happens if you do file a complaint and if it does go to court, there are a number of penalties for the person who is responsible for the discrimination. And these include compensation for damages, civil penalties, equitable relief, so making housing available, fair housing education, or affirmative advertising. So there are many ways to learn more and to take action. Your voice matters, and getting involved in your community and in your local town governance can be an excellent way to raise your voice and help make needed changes in your community. So many towns in Vermont have local housing committees. There are planning commissions and development review boards that address housing issues. And you can also check out your local community's town plan, which generally includes a section on housing. There are several videos in this series that are excellent resources, including the This Is What Democracy Looks Like. A recorded version is also available. And if you're having trouble paying your lot rent due to COVID, the Vermont Rental Assistance Program has assistance for mobile home owners, and Ryan Garrity here at CVOEO is here to help. And the number is on your screen. So thank you for learning more about your fair housing rights and what to do if you experience housing discrimination. I'd like to conclude by saying that the enforcement of our fair housing laws has not been even around the country. Even though these laws are in our state and federal books, discrimination still happens and many people are excluded from housing opportunities. So it's important to not just understand the law and all of our rights and responsibilities, but to think about ways that we can change these systems so that more people can have access to fair and affordable and inclusive housing. So having a good place to live is good for all of us, and it builds community connections and support and promotes stronger communities and helps us all thrive. So if you have any questions, we encourage you to reach out to us here at the Fair Housing Project or call the Mobile Home Program hotline and check out the resources that are online, including fair housing guides in multiple languages and a guide to your rights for mobile home park residents.
Thank you so much for joining us in this virtual space, and take good care.